Hello, everyone, and welcome to a webinar, Financial Crime Investigations in India, presented in partnership between the Legal 500 and BTG Legal. My name is Alan Cohen. I'm research editor at the Legal 500. I'll be brief in my introduction, as we've got a lot to go through today with our impressive panel. We will discuss the origin of investigations, investigation team composition, conducting interviews and post-investigation steps, among others. But first, let me introduce Prashant Mara, who will be our moderator today. Prashant, do you want to say a quick hello so everybody sees you on the screen?
Hi. Sorry, I waved.
Hi. So Prashant Mara is a commercial and regulatory lawyer specializing in investigations and dispute resolution. He heads the disputes and business crime team at BTG Legal and has been helping clients manage risks and protect their interests for close to 20 years. His clients are from across a range of sectors, including technology, energy, defense, automotive, aviation, industrials, pharma, and chemicals. Prashant spends a significant amount of time providing board-level crisis response advice and acting as the interface between his clients and regulators. He was previously co-head of the India group at Osborne Clarke in London and Cologne. And prior to that, ran the India desk of a Franco-American firm in Paris. He started his career as an in-house counsel at Infosys and managed their European legal operations. Finally, I must add that Prashant is qualified to practice in India and read law at the National Law School of India University in Bangalore. I will hand over to you in a moment, Prashant, but before, I would like to remind our audience that they can ask questions in the Q&A box at the bottom of the screen, and that we will have a dedicated time at the end of the webinar where our panelists will answer them. So we'll be together for approximately 75 minutes all together. With that and being conscious of time, I will hand over to Prashant, who I think will introduce the topic and the three other panelists who are joining us today. Prashant, over to you. Get us on the way.
Great. Thanks, Alan. Thank you very much. And thank you so much for giving us this opportunity. And it's great to get in front of a select set of audience this evening or morning or afternoon, wherever you're joining us from. And also joining us is a stellar panel, which who I'd like to quickly introduce. We've got Kristen Bracken. Kristen is the Chief Legal Officer, Secretary, and Senior Vice President at Gates Corporation, which is, as most of you know, a listed US major industrial corporation. Kristen is responsible for all legal functions for Gates, including securities and corporate governance, M&A, litigation, regulatory compliance, patents and trademarks, etc. She's led, the legal function of Gates for a number of years, and prior to joining Gates, Kristen held senior legal.
Prashant, I think you just went on mute.
That's right. Are we having a little
Prashant, we've lost
problem?
your
Not sure if you can hear us, Prashant. We can't hear you here.
Can you hear me, Alan?
That's right. You're back now.
Oh gosh, okay. For some reason, I'm getting some feedback here. Let me just try to see what's gone wrong. Hi, Alan, can you hear me now?
Yes, we can hear you.
Okay, I'm going to start all over again. Apologies for that.
Full start. Okay.
Yeah, absolutely. But a very quick and short summary then. Kristen is the Chief Legal Officer, Secretary, and Senior Vice President at Gates Corporation. She's responsible for all legal functions for Gates, including securities and corporate governance, M&A, litigation. Kristen has had 27 years of experience as a lawyer, specializing in compliance, complex litigation, risk management, regulatory commercial agreements, and transactions. Prior to joining Gates, Kristen held senior legal leadership roles in both oil and gas and energy trading industries at companies such as SM Energy, Forest Oil Corporation, Dynegy Inc., and she's also previously served as an assistant district attorney in Houston, Texas. So welcome, Kristen, and great to have you with us. Wendy joins us. Wendy Weissong is the managing partner of Steptoe & Johnson's Hong Kong office and co-chair of the firm's investigations and white-collar defense group. She focuses her practice on regulatory compliance and white-collar defense of international laws, including the U.S. Foreign Corrupt Practices Act, FCPA, international traffic. Notable experience, it includes leading an international team that represented a Chinese telecommunications company charged with violating US export controls and sanctions, and securing the first ever temporary general license, enabling the company to stay in business during the multi-agency investigation. Wendy is ranked as a Band 1 practitioner by Chambers in its Asia, Pacific, and Global Guides. Additionally, Global Investigations Review named her as one of the 100 remarkable women operating in the field of investigations around the world. So Wendy, thank you very much for joining us. Pleasure to have you with us. And we also have Davina, who is part of BTG Legal and is a member of the firm's Business Crime and Government Contract Practice Group. Her expertise lies in the areas of economic offenses, internet and technology laws, including cybercrime, government contracts, procurement, supply chain fraud, etc. The clients include multiple multinational conglomerates, listed entities, and unicorns for a range of sectors, including technology, defense, energy, chemicals, industrials, and retail. Davina is dual qualified and is admitted to practice in England and Wales, as well as in India. And before joining BTG, she was with the Magic Circle firm in London. So welcome, Davina. So with that, quick round of introductions. We've got inadvertently delayed. What I want to tell the audience today is all of the panelists today have worked in Asia and specifically also in India. So what we're going to try and achieve today is hopefully give you all a bird's eye view of what it means to conduct an investigation in India and what are the specific challenges of conducting an investigation in India. Now, it's it's clear that there are challenges wherever you do investigations, right? It doesn't matter if it's in the US or Hong Kong or China or in India, there are challenges in doing investigations. It's not an easy area of work for lawyers. But what we are going to be focusing on today are a few nuances in the market in India and what those nuances can be and how those nuances are important while conducting those investigations. I want to start off by setting a context. I will not take more than, say, 5 or 6 minutes. I've got about 6 points to go through. One thing that you need to keep in mind when we are talking today is that there's no whistleblower protection policies or regulations in India by the statutory protection. That means that complaining about that person is not necessarily protected under the law. So it boils down to how the company protects that person. And that affects the quality of whistleblowing. It affects the quality of interviews, which we will explain in the future during the course of the presentation. The second point that I want to kind of bring out is, and this is not pejorative in any sense of the term, right? Culturally in India, we are extremely oriented towards crisis management. We're great when it comes to handling a crisis. We're fantastic when we get into mission mode. But when we are not in mission mode, we're not process driven. And as an Indian on the panel, I can say this, right? I've seen for 20 years in India struggle with process. So that's the other mind talk. The third thing that you need to keep and a positive. It's known for its quick decision making. It's known for its ability to change and adapt. But it also means that there are strong individuals within the management structure.
There are strong groups of individuals that form hierarchies or management, power centers, and it's very difficult to, not right, has its own positives and negatives. And combined with the process disorientation, if I might call it so, it's a deadly combination, right? So we've got to keep that in mind as well. You then have a jurisprudence or lack of jurisprudence and lack of experience in specialized investigations. The reason being that, listed companies, in disclosures, treatment of financial accounts, these are evolving structures in India, evolving jurisprudence in India. And therefore, there's a lack of a standardized approach to this area of law or area of investigation. So it's pretty chaotic when an investigation starts in India. And that's again another area that we will explore as we go along. The fifth thing and the penultimate thing that I want to bring out is, once an investigation starts, if it's within the company, that's fine. But if it goes outside of the company, then you have multiple law enforcement agencies with overlapping mandates, right? So it becomes very difficult for companies to control the investigation. It also becomes very difficult for the companies to actually have visibility on where this investigation will end up if external law enforcement agencies get involved. That's another area that we need to be very careful about and plan for it, which we will talk about in the presentation. And finally, one has to keep in mind that there's no concept of plea bargains. There's no concept of deferred prosecutions. There's no concept of fine-based settlements in India. Once an investigation is started internally, that can snowball into an external investigation. And once it snowballs into an external investigation, it will go to its logical end. And I think everyone in this panel and in the audience will probably agree and will not, have any problems if I say that in India, apart from the final result, which may lead or not lead to punishment or fines, the process itself is a punishment. The process of investigation by a law enforcement agency itself, a punishment, which most companies will probably do well to avoid. Now, with that introduction, I want to skip straight to the first question, and I'll put that to to Kristen. Kristen, you have been in-house, and I want to ask you, in your experience as an in-house counsel, especially in Asia, looking at investigations in India, what's the origin of the investigations? Where have you seen the greatest number of complaints arising from? Are they whistleblower complaints? Are they part of HR complaints or exit interviews? What's your experience?
Generally, sorry, Prashant, you broke up there at the end. I'll jump in. I took a look back at my company's history for investigations over the last 5 years. We have had 52 investigations in India, 2016 forward. And 27 of those have been what we might call financial fraud or corruption, bribery, supply chain issues. So that's the major report that we get out of India on a regular basis. The second most common would be sexual harassment, which, as we know, has a very defined regulatory scheme in India. And so you have a very, unlike many other areas that you referenced, do have a fairly clear process to follow when it comes to investigating sexual harassment claims. But generally for us, it is anti-corruption, financial fraud. Almost all of our reports are anonymous. And so what I find as an employer in India, we have just under 1,000 employees in India, Gates does. We have 4 manufacturing and assembly facilities, Laluru, Faridabad, Pune, and Chennai. And we have 2 commercial offices, Chennai and Gurgaon. So the vast majority of my reports come from what we might consider the non-blue collar laboring class of India, my manufacturing workers. Those folks all report anonymously. I think that there is a lot of concern about retaliation generally in India, maybe more so than in many other countries in which I conduct investigations, and I'm in 31 countries. And so anonymity is important. So my reports come from non-management, and they need a way to report that is anonymous. We use a tool. Navex has a tool called Ethics Point, which is the reporting platform that we use. We have a web and we have the phone numbers. You can report on your smartphone, which has really made a difference. We rolled that out in 2018. And that ease of reporting and being able to report anonymously on everybody's got a smartphone, everyone. Being able to report on their phone anonymously from home makes a huge difference. And certainly from my perspective, I think from the perspective of many compliance professionals, you want people to be able to report easily. You know, when you're not hearing from a country, then you're concerned about that country. And so, you know, making a way for your reports to be made easily, whatever the topic might be, and anonymously, I think is absolutely key, and certainly key in India. And it may just be part of the business that we're in, because we are an automotive and industrial product manufacturer, power transmission and fluid power, belts and hoses. And so it's possible that because of the nature of the business I'm in, that is why I get so many, what you might categorize as financial fraud reports, because we have a big supply chain and we're sourcing a lot of materials. And so a lot of reports come related to bribery and hiring family members and some sort of kickback situation related to my supply chain, is the vast majority of our reports.
And thanks, Kristen. It's very interesting that you point out that a large number of your reports come from workmen or workers, and that really shows, that your training and the sensitivity is probably penetrated all the way down to the workers, and that's quite unusual, honestly speaking. And I want to just flip that to Wendy. And Wendy, in your experience in Asia, especially China, for example, where do you see the triggers or the origins of these investigations?
Sure, and I was thinking about the investigations I've done in India, and in particular, and the two largest investigations that I did. One was a situation where a competitor was trying to turn the focus of an FCPA investigation from them and to also inculpate some of the other folks in the same industry. And so they tipped off the DOJ that there was an issue. So this was a competitor. Another large investigation was the result of an audit, which is exactly, I'm sure, Kristen, you're thrilled to hear that there was a routine audit that showed some irregular payments that then tripped off a huge investigation that involved multiple parties in a JV where there were payoffs. So those weren't the result of whistleblowers. They were, in both instances, one was a great indication of a compliance program that was working. I should point out that in the first instance, we had done a risk assessment previously before the tip-off. We knew there was a problem. We also knew that there was no U.S. jurisdiction. And so we were easily able to beat down that particular investigation, and the company was smart enough to use that as an opportunity to strengthen its compliance program. And generally, it seems like most of my investigations throughout Asia come up through anything from a media report, which is a big problem that we had in China, where somebody reported something in the media, which tipped off an investigation. We have had whistleblowers, but again, because not every company has adopted an effective whistleblower program, they're still trying to figure out exactly what to do with those whistleblower reports and to get them surfaced so that they don't get shut down. I think it's probably not quite as smooth a process for originating investigations as it is elsewhere in the world.
No,
I think Wendy makes a good point. I'll just offer one comment on what Wendy said. She's completely right. If you don't have a mature compliance program, then you perhaps don't know exactly what to do with your whistleblowers in India. If you are like my company, it really doesn't matter that there's no whistleblower protection in India, because at the end of the day, for us, a whistleblower anywhere in the world is a whistleblower. And the SEC regulations are going to apply to us, and the UK Bribery Act and everything else. So local enforcement isn't really the concern. As Wendy mentioned, when someone tipped off the DOJ, your reporters can go directly to the SEC. We are a Blackstone portfolio company. We were purchased by Blackstone in 2015. Blackstone has its own compliance line, and I've had reporters from India reach out to Blackstone's compliance to go around Gates because they don't like possibly the action that we're taking or the answer that we're giving them, and say they try to go around us to our parent. I would say that my India reporters are very creative. They find multiple ways to communicate or make reports outside of the usual compliance program.
No, I think that's absolutely right. I think what we have seen, and probably I'll flip that question to Devina. I think what's coming out from both, Kristen, your experience is the existence of a sophisticated whistleblower mechanism means that you've got that safety valve that is working. That you're seeing most of your reports coming in from or through or via the whistleblower mechanism. And Wendy, in your experience, you clearly have seen, and this applies to a lot of companies in India, multinational as well as Indian companies, homegrown companies. The lack of an effective whistleblower mechanism means that you've got to go outside and do something creative to basically vent out your frustrations, because ultimately a lot of these whistleblower complaints are venting out frustrations, or Good Samaritans saying, I'm not agreeing with what I'm seeing. But Devina, maybe over to you now. I mean, you've seen a range of these triggers, right? And what's your view on what you've seen as intended and unintended triggers that then give rise to these investigations?
Sure, thanks, Prashant. Actually taking off from what Wendy and Kristen have said, there is no formal regulatory framework that actually deals with whistleblowers. And that often makes it quite chaotic. The trigger itself can be chaotic. It can be less straightforward than if there was a formal structure in place, because management has to be a lot more sensitive to other informal avenues of receipt of incidents of fraud. So this could be in an exit interview. It could be an auditor's report, a small red flag in an auditor's report. It could be a regular routine HR appraisal or management review process, right? Also, because the whistleblowing processes are still so immature, a lot of the times red flags could also be buried under a lot of information that doesn't seem like a typical whistleblower alert. It doesn't actually seem like a material issue, but there is actually a red flag of a potential fraud in there, and someone has to sift through that and be mindful of what it actually means for the business, right? Because if you don't pick it up early enough, there's a chance that that issue will then snowball into something a lot larger. And if it is escalated at some point to law enforcement, it is escalated to the regulator. A question could arise as to if the company did have that information, whether or not through a hotline process. Why wasn't that acted on? Why wasn't that caught, right? there could also be a domino effect. And, like you mentioned, there are multiple regulators in India. And, if a particular issue is flagged to one regulator, perhaps by a whistleblower or, somebody from, within the management anonymously, or if, as part of an unrelated investigation, for instance, a tax evasion investigation, the tax authority comes across a potential financial fraud, right, which has implications of money laundering or bribery and corruption. A lot of other investigations may also be triggered. A lot of other regulators may then take interest in this issue as well. So once again, the issue really snowballs and escalates. So whenever a company receives any sort of report, any sort of, big or small, any sort of alert, even outside of, if you have a sophisticated hotline system, that's great. But, even if you don't, if you receive an alert, it does make sense to, conduct a minimal check to see, before you decide no action is required. So even if there's a minimal actionable amount of information that comes up, do some preliminary, review of what the next steps should be.
Thank you. I think that's a nice segue into the next question that I have for Kristen, and taking from what Devina said. Kristen, I know Gates has a pretty sophisticated whistleblower mechanism in place, but as in-house counsel, how do you really kind of sift through that, possibly, material whistleblower reports and those that are, in our experience, all of them, those that don't have substance? Do you have like a kind of a litmus test that you do? Is there like a team that looks at it and then decides, yeah, you've got more material, that we need to look through, and then constitute a bigger team? How do you start the investigation? How do you commence the investigation, and how do you get together a team to do it? Kristen, you're on mute.
I apologize. We have a triage, which I think is sort of what Devina was referring to. We have an internal compliance team that reports to me. We have the head of that team, who is an employment litigation compliance lawyer. We have a U.S. employment lawyer on that team, and we have a certified non-lawyer compliance professional on that team who actually comes from China. Which adds a great sort of balanced view to my team. And these reports come in to all four of us. We review them and we do an initial triage. Devina is correct. You have to sometimes do a little bit of work to figure out whether you have an issue that needs investigation or not. Your issue may simply be an employment management issue that needs to be referred to your local HR team, for example. Or your issue may be a safety issue that doesn't really require investigation, it requires a fix, and it needs to go to your local HSE team. Or it may be something that has to do with your financial systems. That's serious, and maybe that needs to go to your VP of internal audit. So, you have all of these support functions, at least within Gates, and some of these investigations may simply be a referral to that team. Maybe an investigation assigned to an individual in that team, still the investigation managed by my team. Maybe you need more information. That's the other reason having some sort of program in place like we do with our NAVIX Ethics Point gives you the opportunity to communicate with anonymous reporters, allowing them to remain anonymous. So you can send questions, have a conversation, have a dialogue, obviously through email, to get more information. So you can make an informed determination about whether you need to conduct an investigation here. And then once you have an investigation that needs to be conducted in India, in my opinion, you need to put together the appropriate internal and external team. It is very rare that you will have an investigation that is not going to require some form of IT assistance. Gathering emails in the background, pulling electronic documents, looking at logging reports, whatever it might be. And so you're always going to need IT. In my company, you're always going to have a member of compliance. And then you have to have your appropriate partnership on the ground, particularly in India. I have in-house lawyers in India who work for Gates. They are commercial lawyers. They are not experienced compliance lawyers. And so in India, I am 90% of the time going to a firm like BTG, and we've done many investigations together, to get the right partnership externally. That might also include a forensic specialist externally, not just your lawyers, but IT forensics. There may be reasons you don't want to use your internal IT. You may not have the capability internally. You may be looking at an issue that might be big enough that you know sooner or later I'm going to be talking to a regulator about this. So I want an objective third party to be doing that piece of my investigation, preparing that report, creating that chain of the word I'm looking for is escaping me. So that you have the information flowing correctly. Where did it start? Who had it when? Where did it go next? Where is it being retained? So, you know, putting together the team from the get-go to me is the absolute key. And you don't want to, oh, let's start and see what happens. And then, oh, after I've interviewed 4 people, then I need to bring I now know I need my external counsel in India. And oh, now I figured out I need to go look at emails. So now I need to bring in IT. It's much more effective for the team members. If you identify the team ahead of time and you sort of have a kickoff call, which Prashant and I have had many times, and you talk about what does the investigation look like? What do we think we're going to need to do? You may have team members on that call who end up not having to do a lot, depending on the direction the investigation takes, but it's better for everybody to know what's happening from the beginning. They're much more effective in their role, whatever it might be, as part of the investigation if they are fully informed in the beginning, if they know who the team is, who they can communicate with, and what the general steps are going to be to kick off the investigation. I find that to be much more effective. Otherwise, I find your investigation sort of spin off and you're ending up going down rabbit holes. And additionally, if you end up in a situation where you have to talk to a regulator about something, you have not had a well-controlled, identified investigation that is easy to present and explain to a regulator to the extent you need to. So to me, the investigation team composition and kickoff really sets the tone for your entire investigation.
No, and thank you for that, Kristen. I think one thing that I want to add here before bringing Wendy in is the first few hours or days of an investigation being kicked off, I think is very critical because, as you rightly pointed out, there's no going back. You have your first conversations, you have your first interviews, and whatever you want to do to maintain confidentiality, there is always a risk that it will get known. People will talk about it. There'll be water cooler talk, et cetera. So getting that team in place and getting them to actually start on that, approach, which is a sophisticated and a clear approach, I think is extremely important. Wendy, I know that a lot of external counsel are brought on board for reasons of privilege and to establish privilege. But other than privilege, there must be more reasons why external counsel need to get involved right from the word go, as Kristen said. What are your views on what's the role that external counsel will play and when is the right time to get them involved?
Sure, thank you. And I think one of the quickest things that I encountered when I was doing and have been doing investigations in India, one was the privilege issue, obviously, because it's just really up for debate whether or not there is a privilege if it's internal counsel. So if you start embarking on the interviews without having external counsel, without having real solid privilege protection, there is a real risk if there's reports, if there's document collection, if there's anything going on before you have external counsel, if you get a particularly aggressive investigator, government investigator, there's a real question about privilege. But putting that aside, for companies that aren't as well organized again as Gates, external counsel can come in and put in a governance program, sort of a structure, making sure that there is a very regularized way of proceeding, where you've got a steering committee put together, where you've got document collections, where you've got preservation notices, where you've got those preservation notices for all of the documents that are going to be collected and the information that's going to be collected, making sure that those are all tracked, making sure that you've got the information that about that particular investigation. You're talking about water coolers, and discussions. That's so important, but so critical. Making sure that only the people who need to know about this investigation are privy to the details, because again, if it gets beyond the water cooler, if it, people start talking to their neighbors and you never know where that information is going to go. Figuring out, how, when it's the time is right, how the communication is undertaken strategically, to make sure your stakeholders, your suppliers, your business partners, any media, government, all of the different people that might be involved, making sure you've got a coordination strategy. And you bring in external counsel who's done this many times, you're able to get the appropriate structure for that investigation, the appropriate governance of the investigation. And then having a team that's completely objective. There's difficult conversations that have to be had, which are tough internally, where the internal legal counsel is having to confront management about decisions. Having external counsel that can very diplomatically, but very objectively handle that kind of questioning is another very key role that external counsel can perform. And looking at a particular pattern of conduct that may seem, perfectly innocuous, looking at it from how a government regulator would look at it, bringing that outside external point of view. There's practices that build up within a corporation. And I don't want to call them workarounds, because that sounds, something nefarious. But there's in India, there's a lot of layers of approvals that you have to have with different agencies, different involvement, and so companies work out a way of getting through all of those approvals there's nothing wrong with them. But if an outside regulator looks at them, they might look at it a little bit more askance. And so making sure that that is objectively viewed and explained. And then on the other side, having the external counsel explain that to any outside prosecutor, why those mechanisms are innocuous and they're not as nefarious as they might look on first impressions. So having them serve as kind of an interpreter. So all those different roles, I've served in all of those roles as external counsel, and they usually prove useful to the company when they're conducting an investigation as they go along.
Thanks, Wendy. I think what's coming from this conversation, and I'll pass this on to Devina, is you need guidance from the internal team and a strong legal counsel. And Kristen has played this role for us a number of times to tell us, here's the lay of the land, and here's what you can expect if you do X, Y, or Z, right? So it's a lot of that prep work that the strong legal counsel is to do. And then at strategic points, the internal legal department has to step in, course correct, say, yep, this is fine, this is not fine, purely from a how does the company operate point of view without kind of interfering into the integrity of the investigation itself, which then means that you have the external counsel who are kind of taking the lead and making sure that it's kind of insulated to a large extent from all of those challenges and all of those pulls and pushes that, Wendy, you were talking about, internal politics or those hard conversations, external regulators and how they look at it, and the approval process. So Devina, I know it's a very complicated, kind of scenario in India. And how does team composition really play out in your experience?
Sure, Prashant. Actually, a lot of the points that I would discuss have been covered by Kristen and Wendy, but I'd be glad to give our joint experience here. There's a number of factors that go into putting a team together for an investigation, and the first one is, like Wendy said, you need a team that's objective, right? You need someone on the team, or rather everyone on the team, who will be able to provide an unbiased and an unprejudiced perspective. So this plays out in terms of conflict of interest. If there are people from the internal team on the investigation panel, or the investigation team, be sensitive about their roles and their profiles, right? Not just direct reporting. Is there a dotted line reporting? Is there any other reason that there might be any sort of conflict of interest? Does this person play into appraisals or ratings of any of the suspected players in the fraud in any way? Right. And, we've actually seen this play out in a number of whistleblower alerts, where the whistleblower will specifically ask for external counsel or for overseas headquarters to take on and run the investigation. Or, like, Kristen had mentioned, they maybe bypass the local whistleblowing mechanism completely and, maybe reach out directly to headquarters, someone they've been in touch with previously, or contacts that they've just sourced online, right? And this is because, partly, like we discussed, there's no protection to whistleblowers under law, and also partly because of the perceived notion or the perceived fear that if everything is kept at the local level, if the process is kept at the local level, there may not be confidentiality. And like Kristen said, there is a fear of retaliation. Whether or not this is a real fear, an illusory fear, it is something that you still have to account for, and something that you still have to provide for when you're composing the investigation team. Apart from conflict of interest, there is also unconscious bias that will play a role in judgment formation, in conclusions and recommendations. So what could feed into this unconscious bias? History, historic behavior of an employee, which may have been fed up the chain and the team, even if the employee doesn't directly work with everybody within the team. Something like whether the company is working is operating in a unionized environment. Anticipate unconscious bias, and people with unconscious bias should ideally not form a part of the investigation team. Something else that Kristen touched upon is a multidisciplinary team. So, based on the fraud, in addition to legal counsel, you may need IT forensics experts, you may need accounts forensics, cost accountants to pursue and corroborate different lines of technical inquiry, look at the money trail, look at ERP entries, look at historic invoices. Something else that's quite important, especially in the Indian context, is someone who can appreciate evidence collection, evidence preservation, and corroboration. I think we have in the past seen internal teams have had interviewees sign statements on company letterhead. And that's not a great process at all, because it can definitely be challenged down the line for, as being coached or, as being coerced. So you need someone on the team who understands how to collect evidence to make sure that it is admissible to, as far as possible. And someone who is, knowledgeable about preserving the chain of evidence, like Kristen was saying, who has had access to the materials, who has been, maybe somebody from IT has downloaded it, where is the pen drive gone to, and there are regulations for all of this. So someone who is, aware of how the system works. And also someone who is sensitive to corroboration processes. So someone who won't be prejudiced or swayed by one level of evidence. So Prashant, in our experience, I think, unless there's something you'd like to add, this is what our experience has been in putting together an investigation team.
Well, thanks, Davina. And I think that's absolutely right. I think the composition of the team in India, as elsewhere around the world, makes a lot of difference. One other thing that I want to add here, and again, I'm pushing the envelope a little bit here. I've seen a number of investigations in India getting derailed because investigators take on the role of investigators in a slightly disruptive manner. I mean, I think one has to be sensitive when doing the investigations that, of course, there's need to preserve evidence, there's need to collect the evidence, but one has to be sensitive to the fact that we're doing this in a business environment, in a company that is a going concern, that has a business to run, that has a reputation to protect. So the only thing that I want to add here is I think the team composition should be such that you have the team that is sensitive and keeps that sensitivity ongoing during the course of the investigation while collecting evidence. Once in a while, I've seen this happen, that investigators almost act like they are the FBI and go and do a complete raid on the premises and then pull up people, which frankly has no legal bearing. I mean, yes, we've been appointed by the company to do the investigation, but it's not that we have statutory authority to do all of that stuff. But moving quickly on, I'm conscious of time and we have a number of questions. Interviews. Maybe Wendy, I'll start with you and then go to Kristen and then Davina. In your experience, as an external counsel, how do you look at interviews? Is there a kind of a one solution fits all interview pattern that you use, or is it very fact specific?
No, I bring in the same checklist for every investigation I did. I run it exactly the way the FBI does. Interviews are probably my favorite part of an investigation because you really get to know the company through those interviews and the people, and having empathy because, it's an awkward thing to be called in to talk about an uncomfortable topic. And so I always try and have a lot of empathy for the people that I'm talking with. I am a former prosecutor, so when empathy doesn't work, I do have other attitudes that I can bring to bear. But, I start out from, trying to make sure I understand where that person's coming from, why they might have, made a decision the way they did, and get to the facts and try and establish, a rapport with the person that I'm talking with. And most people respond very well to that. It's kind of astonishing sometimes what they'll confide in me. And in the interviews, because they feel uncomfortable. They've been asked to do things perhaps that they don't quite understand, and so they'll if you can get on the same wavelength as the person you're speaking with, it makes all the difference in the world. And so when I talk, I'll talk about the individual and what their background is and try and figure out what their roles and responsibilities. That really is kind of the template, but it also introduces the relationship that you can build, and then kind of focusing in using documents and making sure that the questions are really tailored to what the particular situation is, what the person's role was in the situation, and what their thoughts are about how the company got into a particular position. The whole time I'm doing this, I'm jotting down notes and really listening to what the person's saying, because, just asking your checklist of questions, if you're not really listening to what the answers are, you may miss a whole line of relevant information. So, I try to be very, very interactive and think about, what the answers are. I generally, when we do these investigations, when we do these interviews, I'll generally have somebody there taking notes. We're very careful to make sure that, it's not a transcript, and I make that very clear to the interviewee that, we're just jotting down thoughts and impressions. I know that, there's with these interview notes, again, these interview notes are very important to the investigation. You don't want to waive privilege. We generally do not give the interview, the final interview memo to the interviewee to review and sign, because we count on making sure that we're listening closely and that the information we're putting down is accurate. Because once you give it to the interviewee, then there is no attorney-client privilege, and so you've basically waived that. I always give what we call an upjohn warning at the beginning of an interview to make sure the interviewee knows very well that I represent the company, not the individual, and that the company can decide in its best interest to waive the privilege. And I can't object to that, and neither can the employee. That sort of formulation works better than just saying, and the company can tell anybody it wants to, and you can't do anything about it, which immediately puts the interviewee on edge. So I try and do it in a softer way, but be very clear and make sure that the interviewee acknowledges that they understand that. And then again, remind them at the end of the interview that everything we talked about should be confidential, and they want to help the company. And if they go back and talk with other people, that waives confidentiality and will really hurt the company. And, again, people understand it if you put it in not legalese, you put it in a way that they'll understand it and can relate to, because generally, people are proud of the companies that they represent and they want to help with the investigation. Now, of course, if somebody comes in and, it's clear they're hostile, you adopt a different way of proceeding and making sure that they understand that, that you are recording, you're, writing down what their answers are, and are they very sure those are the answers that they want to give, and then if there is a representative of the company present, and sometimes, that's how we structure the interviews, calling on that representative to remind the employee of, disciplinary procedures that could go into effect if they're not being cooperative. That kind of thing becomes, very important when the interview sort of goes off the tracks. But, just making sure that they understand what the context is, what you're looking at, not disclosing anything, because they could go and talk and formulate, sort of joint plans to disrupt the investigation, that kind of thing. But just being very mindful, very professional as you're doing it. I mean, I know we're not going to talk about remote interviews today. I don't think we're going to, but that, that's a whole nother topic, how you do that. But I guess those are the key things on how I approach an interview.
Thanks, Wendy. I think what I pick up from here, which I completely, recognize in our role as well. There's a combination that every external counsel in an interview needs to have, which is a certain kind of discipline and structure. But within that discipline and structure, the ability to be agile and adaptable. Because the questions that you ask will lead to answers, and those answers will lead to different questions than what you had actually planned. But at the end of the day, you need to not lose sight, of the end objective or the end goal, because you can really go off tangent. Kristen, I know that when we worked, there was a certain kind of message that was passed on, either institutionally or via to people, and then them that message percolating down, that these interviews are critical, they're essential. They kind of set the tone from the top, really. How do you really manage that messaging when external counsel who are pretty much unknown quantities go into a shop floor or to a manufacturing unit and start saying, I need a room and I need these people, 10 of them, to be in the room for the next 8 hours? How do you prep for it? How do you talk to the senior management and say, I need this to be done? What's the background preparation for these interviews, which obviously, as Wendy rightly said, is a critical component of any investigation?
Agreed. And I was going to mention that in relation to interviews with senior management. And then, of course, for example, interviews with folks on my manufacturing facility floor. I find it is always essential for me or a member of my team to introduce my outside counsel interviewers at each level. And so, and this gets back to your, sort of reference of a hierarchical sort of structure in India. And you kind of have to do it in the right order so that people don't get offended and believe that things are, proceeding as they should be. And so there are always introductions from me to this most senior manager involved, and then the next level of leadership. Obviously, I can't do an introduction to every individual on our manufacturing facility floor, but I have local HR assist with that and let employees know ahead of time that investigation is going on, who's coming, who's going to interview them. You do a lot of preliminary work. There can be the rare situation where you actually want to just dive your lawyers in with no warning and see what kind of information you need to get. And that certainly happens. I'm sure Wendy's been in those situations as well. But in general, making the introductions and letting people know what's going on. And in my life at Gates, having people understand that headquarters is paying attention to this, and this is important. And it's not just going to stay with senior management in India, can be a very important message, particularly for the non-management folks that you are interviewing. The other thing I would add, really important thing in my experience to offer is think about who your interview team is, and think about including not only men and women, but also younger and more experienced people. Because depending on who is talking to who, you might get a situation, as Wendy indicated, where you have developed a rapport, where you may get a witness to talk to, for example, Davina, who is not going to talk to Prashant. And that happened to me in a very important investigation in my Laluru manufacturing facility, which is a wonderful story on its own. But to summarize, we needed to find out who had stolen information off a senior woman leader's computer and then sent it to every member of the employment in the Laluru facility and external media and et cetera. And the person who knew who had done that was a young woman playing sort of an office manager role, working for the senior leader of the Laluru facility. She's the only one who knew. It was very movie, like who knows what's going on? The senior administrative assistant. She always knows everything that's going on. Well, she did. And if we had not had a young woman as a member of that interview and investigation team, we would have never found out, because she would not have told anyone except the young woman that she had a cup of tea with, and just, sort of casually interviewing her. We didn't really think she knew anything, but, she might, and there she is, and she knows everything. And it had to be the right person interviewing the right person. And so you also need to think about that when you're setting up your interviews.
No, I think that's a super kind of war story, Kristen. Thanks for that. I think there's a lot that can be just discussed on the interviews. But Davina, and I'm conscious of time, Alan, we're going to probably take another 5 minutes. I know attendees will leave about 9:30, but just to give this a proper closure, if that's all right, Alan.
Absolutely.
Probably
yeah, 5 minutes. And then I don't know if you've seen, we've got a few questions from the audience as well.
We do. Yeah,
okay,
absolutely.
Fantastic. So yeah, okay, carry on. 5 minutes is fine.
Prashant, I wonder if you want to just jump to the post-investigation steps, if that might be better. I wouldn't mind.
Yeah, sure. I mean,
okay.
Yeah, let's spend a few minutes on that. And I want to just, I know we've got, post-investigation steps as the next topic, but I want to just, broaden that a little bit. And I want to bring in governance here, because finally, I think investigations kind of lead to, very often lead to governance issues. And maybe I'll bring this question to, Davina firstly. And Davina, in India, obviously, it's a complicated story, right? I mean, management faced with some tough decisions when the investigation report comes out. how have you seen, what are the options available to the management in India really when an investigation report comes out?
Sure, Prashant. So typically, I mean, when we write our report, we will set out our findings, we'll set out our recommendations, and all of the evidence we've gathered, and the evidence also, the strength of the evidence leads to the recommendations we make, and these can be internal recommendations like cleaning house, disciplinary processes, termination of employees. They can be legally mandated measures like disclosures and reporting to regulators, and they can also be civil and criminal action against the perpetrators of the financial fraud, right? The most immediate measure is typically the disciplinary action or the termination. I mean, I say immediate, but it's not a spur of the moment thing. Of course, you have to still follow all of the processes when you are terminating or disciplining an employee, right? Under labor laws, they might be entitled to a disciplinary hearing, the right to be heard. There may be other conditions under their employment contracts. So, despite the strength of the evidence, all of these processes have to be followed to avoid, a claim or a challenge for wrongful termination down the line. Then coming to civil action, I think it's relevant to highlight that it's very, very rare for courts in India to award punitive damages. So, even if there is evidence of fraud, even if there is evidence of a number of employees being complicit in this fraud, companies shouldn't expect that they will be able to recover significant sums of money from these employees as punitive damages. Right. So at times, based on the nature of the fraud, some companies may think that, it's not worth pursuing action against the employees, and they may clean their shop, they clean the shop floor, and, that's the end of it, and that's their objective achieved. Right. But, at times, based on the situation, the company may not actually have the option to let go of this civil remedy. For instance, if there is a material deviation, like something that affects the company's financial statements or accounts, and it's a listed company, or if there's pressure from investors, or perhaps it's an insurance requirement, to recover damages, or to at least apply for recovery of damages, or if it involves a competitor, for instance, in a data theft issue where a competitor has access to your data. In that case, the company may not have the option but to proceed with civil relief. Right. And in this case, the typical relief that is sought is a suit for recovery or damages. Coming to very quickly the criminal side of things, criminal prosecution is possible for financial fraud. It does qualify as fraud under the Indian Penal Code. A number of other provisions like cheating, breach of trust, and so on may also be triggered. The IT Act may also come into play if IT resources have been used to perpetrate the fraud. The problem here is that, when you want to criminally prosecute someone in India, what you have to do is lodge a complaint with the police or approach the criminal magistrate, who will then direct the police to commence an investigation. This is the way things are done, on the criminal side of things. And unfortunately, once that investigation starts, it's an extremely long drawn and extremely cumbersome process, on the company in terms of the administrative burden. The company has no control over the process, and it could take years to reach a final outcome. So again, a lot of companies look into whether it actually makes sense to go ahead with criminal prosecution, to go ahead with filing a complaint. But here as well, a company may not have the option to decide whether or not to file a complaint. And this again ties in with the nature of the fraud. For instance, if it's something severe like anti-money laundering, or it triggers bribery and corruption laws, then it makes sense for the company to get ahead of this, to be the first person to report the instance. If it's picked up by regulators down the line, it's picked up by law enforcement agencies down the line, it could be an issue as to why the company didn't report this in time. Why, do they have something to hide? Is there a cover up? Is there abetment? So, unfortunately, there are pros and cons to each approach. It's not a binary decision. It is a reasoned decision that the management has to take when looking at recommendations.
I think those are really, really good points. And I'd like to quickly bring in Kristen and then close with Wendy. Kristen, faced with these choices, and I know you've been faced with these choices in the past in the investigations we've done, how does the management go about making that decision? How does it weigh the pros and cons? What's the, what are the factors that influence a decision one way or another? I think you're on mute, Kristen.
Yeah. Yes, sorry. I would say, and it sort of goes to the other topic, which is the report. Certainly for me and for my decision makers, the report and an executive summary of the report are sort of key to walking through what happened and what are our options. So I just wanted to add 2 minutes on that. It's really important how you write the report. I think Wendy would agree with me, not just for internal decision making, but for any sort of external communication. And writing a good report is a skill. Not everyone can do it. And you need to have a verbal discussion before you start writing your report so that everybody agrees on what the report's generally going to say, what the recommendations are generally going to be. You don't want to have multiple iterations of your report. So you have a verbal discussion, you write a good report. I hope not embarrass Davina by just throwing out here that, as Prashant said, I've been doing this for 27 years. Davina wrote the best investigation report I have ever received from anyone. And it was a very complicated investigation. It was so well presented. It was so easy for my management to digest a tremendous amount of information. It was amazing. So I would say don't underestimate that piece of your process. There's going to be decision makers involved who do not have time to read every witness interview and every document and do all the legwork that you all did to understand your investigation. And so how you communicate that to decision makers is of primary importance. I think Davina very well covered the options that you weigh as a decision maker. Our decision makers are always management. They're not the legal department. The folks who are actually in the chain of command of the individuals who engaged in whatever the conduct might be are the appropriate decision makers. That might be all the way up to your CEO or your COO or your CFO. It depends on obviously where the conduct has occurred. I would offer that there is a lot of opportunity to take issues to the criminal justice system in India, and we never choose that. As I think Prashant has referenced, a criminal investigation in India is not within your control. And you may have an idea that you think that pursuing this employee from a criminal perspective or some third party is the right way to go. You very quickly lose control of that process, and it very often will not end up where you want it to. And so we generally almost never take the criminal route, unless it's an actual crime, a theft, something like that, then you have to report that to the appropriate authorities, and then you just hand that over, and they're going to do what they need to do. But if there is a nuance of whether the company wants to pursue an employee for something, we rarely go the criminal route.
Thank you, Kristen. And Wendy, I think, keeping in mind that we've got a couple of minutes left, but I have a slightly complicated question in the sense, in cross-border investigations, I see that reporting or reports, written or interim reports, are relevant in two stages. The first stage is, whether it triggers any reporting obligations in your jurisdictions or in other jurisdictions where there is such a reporting obligations, namely the SEC or the DOJ mainly. So that's kind of like a threshold question, right? I mean, that's something that you need to work with your Indian Council or Asian Council to figure out quite early in the game. And then you have the impact of the final report. How do you kind of, measure this, and how do you identify the right time to actually trigger that reporting in other jurisdictions? And then what role does the final report play in that investigation, which is probably going to hit the company harder than any investigation in India, unless it's again reported to the regulatory authorities here in India?
Sure. So with regard to reporting to Indian authorities, we always engage with local Indian council to make that decision. And generally they go the direction that Kristen just suggested that the Indian authorities aren't necessarily involved, but that's a decision that we would not, given that we're not Indian lawyers ourselves, we would not undertake ourselves. But from the moment that the investigation starts, we think about the cross-border implications. The entire investigation is organized and governed by the concept that at some point there may be a cross-border interest, and identify all of the different countries' law enforcement that might be interested in the outcome of the investigation. Keeping that in mind so that the interviews are structured to account for that, the questions, the documents that are collected, everything. And then when the investigation's concluded, I really take Kristen's point, making sure that the report is something that the company can live with. If the company is going to decide not to report this, that they've cleaned it up, they've remediated it, that kind of a report, that decision is in some ways different, and the report's going to look different than a decision that there's going to be some involvement of foreign authorities. And so, the recommendations, you want to make sure that they're sustainable, they're going to be acceptable to the company, and that they're realistic, and that you're not going to say you're going to have to shut down the factory or whatever, if the company of course cannot do that. And so you want to work with the company to figure out what the recommendations are, what that remediation is going to look like, and so that there is a record in case anything happens, then there's a second violation. Or in the case that I was talking about, where we knew that there was a problem, we remediated it, we recognized that there was no jurisdiction, and so we wrote the report, closed it down, and then DOJ opened it up again because of that competitor's tip. So we had a complete record. Even if we hadn't been engaged for that second investigation, there was a record of what had been done and why there wasn't going to be a record. As far as engaging with, there are very, very few actual reporting obligations where you must report. It's always a decision by the company, unless of course, a government initiated investigation, then of course you have to, respond to that. But voluntary self-disclosures, that's exactly what they are, voluntary. And there's reasons that would weigh in favor of engaging with a foreign law enforcement authority that strategically are beneficial to the company, and how you would put together that report for that, and what you would disclose, how you would disclose it, how complete you are, how you cut off certain aspects of the investigation, so that they don't say, oh, you should do a 10-year look back, not just a 5-year look back, that kind of thing. So, again, each way along the way, each step along the way, there's an analysis going on in the back of my mind as to where this investigation could possibly go, and engaging very closely with in-house counsel to make sure that everybody's on the same wavelength as to where the investigation will ultimately go. And I love to hear that the report that Davina did was so good, because a lot of times those just get filed and nobody ever actually reads them, and there is a lot of work that goes into those to make sure that they're useful for the company, and that that they're easily digestible at all levels of the review. So that was great to hear, Kristen. I'm sure Davina was really happy to hear that, because we don't get a ton of feedback like that when we do those reports.
Absolutely. Thank you very much, Kristen. I'm really pleased. Thank you.
So thank you very much to all of you. I think we've got a few questions. I'm just going to quickly flip it, a quick fire round. Kristen, this one's for you. Can technology help in investigations? And I think the answer is yes, because you've already got what looks like a super app, which has increased the kind of transparency and the ability to communicate with the whistleblowers. So maybe if you just want to elaborate a little bit on that.
I think technology can help in two ways. One is, as I referenced, having in place a web portal reporting mechanism that allows people to report anonymously, I think is absolutely key if you want your compliance program to be effective. Nobody picks up the phone and calls anymore. So you've got to make it easy for your reporter to reach out. Obviously, technology advancements make a huge difference in the investigation itself. The level of back office IT that you have that allows you to identify whether people have accessed systems, when logging reports, your malware and ransomware type of screening systems. We have a system in place where even me or my lawyers can access the email of an employee without the employee's knowledge. We can download, copy, make snapshots of computers, all of that done behind the scenes without ever having to notify the user. Obviously, all of these levels of technology make a huge impact on the effectiveness of your investigation.
Well, thank you. I think that the impact that technology has is undeniably huge, and the lack of it, if it's chaotic, makes the investigation go round and round in circles, and that's the experience we've had as well. Wendy, this one's for you. Would it be advisable to keep the informant or the whistleblower informed of the process, or just share the end results?
Sure, I wouldn't do either. What I do when you have the whistleblower, you want to make sure the whistleblower knows that the investigation is proceeding, that you're taking it seriously, that you've documented it. You want to acknowledge all of that, because you don't want that whistleblower to think that you're not doing anything, and then the whistleblower gets frustrated and goes to the government or the media or whatever. You don't want that to happen. So you want to make sure that the whistleblower is very careful, is carefully communicated with, but you don't want to do anything to find out who that whistleblower is, because you want to make sure, if they want to be anonymous, that you recognize that, because if you find out who it is and there is any disciplinary, even if it's unrelated, they can allege retaliation because you found out who they were. If you can keep that person anonymous, that's the best way to proceed. As far as sharing the end results, no way. That's something that you have people that you need to communicate that with. You do not need to communicate that with the whistleblower. If you decide to close the investigation without taking any action, you can communicate and say, we've carefully investigated, thank you so much, and appropriate action has been undertaken, period. You do not want to, because again, that's a waiver of attorney-client privilege, and the whistleblower isn't entitled to that information, just entitled to respect and dignity and protection of their anonymity.
Absolutely, and I totally agree with you. There's an interesting deviation from this principle in India, and Kristen, I think you referred to it, which is the Prevention of Sexual Harassment Act and the investigation procedures under that, which require some sort of disclosures and some sort of reporting obligation on the company on what's actually happened in terms of closing that investigation. But I think, Wendy, you're absolutely on point in terms of financial crimes and financial frauds. That's probably where the recommendation will lead to. And the last question is for Davina, which is, has the latest economic and health crisis, the last few, have those had an impact on the frequency and complexity of financial crimes in India? Have you seen, I think in other words, have you seen these financial frauds increasing in the last 4, 5, 8 years? And you're on mute, Davina.
Sorry, I'm back. Absolutely, Prashant. Definitely speaking to the pandemic, it's changed the way that we do business. In India, we're used to a very prescriptive managerial supervision, style of working, where your manager is sitting a desk away. There's lots of checks and balances in the physical environment. But now we've moved to a remote system, and that relies on, self-regulation and self-discipline. So the risks that the business is exposed to are now different. Not every business has the right kind of or enough data security controls, enough checks and balances to kind of keep an eye on all things. There's new issues that have arisen, and also I feel like that what we identify as a misconduct, the idea of that has also changed, right? For instance, we've had clients who've given, work devices to their employees, and their children have been using it for online school. Their spouses have been using it for entertainment. You can't stop this stuff, but they do have access to client proprietary information, and that's not misconduct. There's no malfeasance there. There's no mens rea. It could, if there is an issue, it might be, negligence. It might be completely unintentional. That said, Prashant, I think you'll recall we did have an instance where someone was sending out fake fake recruitment requests or fake recruitment to third parties and then collecting money as job offers. And so there are instances where, issues of fraud and malfeasance could arise. But, the classification of what is a fraud has changed.
Yeah, absolutely. I think on that note, which kind of speaks to how agile and adaptable lawyers and in-house as well as external counsel have to be, because what's fraud is changing, how it's perpetrated is changing, and in a remote environment, to monitor it, to investigate it, and to bring it to closure in a satisfactory way, while keeping that empathy alive, while being disciplined about it, and while protecting the company's interests and the shareholder value, is also changing. And that obviously impacts how you deal with regulators across the US, in other parts of the world, and in India. So on that note, and I know we've gone way over our time, thank you so much for our spectacular panelists and a stellar performance. Thank you very much for bringing life to this, what could have been quite a mundane topic, with all the war stories that you've brought on board. And it shows that there's a lot of experience on the table. And thank you very much to Legal 500 for hosting this as well. And all that I have to say,
today.
all that I have to end with saying is that there was a fourth panelist, was uninvited. That was Murphy, playing havoc with my IT and internet. But I think we managed to kind of get through with minimal interruptions. So thank you very much once again, Kristen, Davina, Wendy, and Alan. With that, I'll probably pass on to Alan.
Thank you, everyone.
Yeah, thank you for saying. It's a privilege to have you all today, and I'll see you soon. Goodbye.